Hello, friends. Welcome to Lex Master Academy. And now we will be beginning with a new topic from Transfer of Property Act, and it is Lis Pendens. Lis Pendens is provided under Section 52 of the Transfer of Property Act 1882. It says during pendency in a suit in a court within limits of India, the suit should not be collusive, and suit in which right to immovable property should be directly and substantially an issue. If the property is sold in such a case, then it is sold only to the subject of the decree. Here it is pendency, and pendency will include execution proceedings, as it is stated in the explanations. Lis pendens means litigating or a suit pending in any court within the limits of India. If the suit that is pending is pending in a foreign court, then this doctrine will not be applicable. The suit should not be collusive. Collusive means it should not be fictitious. The contest should not be unreal. It shouldn't be filed for the only sole purpose to or an objective to harm any third person. For example, A have certain self-acquired property and his LRs, legal representatives, or the person who will inherit his property are X and Y. A's brothers are B and C, and they own it as a joint. This contest that the property is not a self-acquired property rather than a joint Hindu family property. B, the plaintiff files a suit against X, Y, and C. Here, C collusively accept that it is a joint Hindu family property. So this the filing of the suit here and making C as a defendant in just in order to have an admission from C that it is a joint Hindu family property suggests the suit is with a collusive nature and just in order to prove the plaintiffs, the B's and C's contention that the property is a joint Hindu family property. B, bona fidely, B and C should, as a co-plaintiff, should have filed the suit against A, X, and Y, where the issue would be whether the suit property is a self-acquired property or a joint Hindu family property. In such a suit, the right to immovable property should be directly and substantially and specifically is an issue. That is, the suit should be related to the title of the property, that is, the ownership of the property. And in such a case, if the property is sold by the parties to the suit, that is the plaintiff or the defendant, and it should be sold, it should not be a gift, then it can only be sold subject to the decree, that is the decision of the court. Because the logic behind section 52 is a constructive notice that a suit is pending and it is matter of sub judice in the court of law, so the property can only be sold subject to the decision of the court. It is also based on the rule of necessity. It is also important because in PT this could be there, that is according to the rule of necessity. However, there are certain exceptions. It could also be sold under the authority of the court or under the terms which the court can impose. This principle is based on the landmark case of Bellamy versus Sabine. After that, only it was incorporated in the Transfer of Property Act. Further, we need to just see how we can frame it, the case accordingly, the answer for section 52. This section 52 incorporates the doctrine of lis pendens. Lis means litigation and pendens means pending. Doctrine of lis pendens is based on the maxim pendente little nihil innovature, which means nothing new should be introduced during the pendency of litigation. In other words, this doctrine means that during the pendency of a suit, no new interest or title should be created. English court in Bellamy versus Sabine held that the doctrine is common to both law and equity. That is, there is a statutory law, that is section 52 of the Transfer of Property Act, and also it is based on justice, equity, and good conscience on equitable principles. As a matter of public policy, this doctrine prevents the parties from disposing the suit disputed property in such a manner so as to interfere in the court proceedings. If the property is transferred during the pendency of the suit, then the transferee is bound by the decree even though they do not have the knowledge of the pending suit. So, the knowledge of the pending suit is immaterial. Certain cases are outside the purview of Section 52. For example, review. If review is pending, then Section 52 will not be applicable. In cases of friendly suit or a collusive proceeding, Section 52 will not be applicable. So we can also have certain essentials. That is, further, firstly, there should be a pendency of a suit or proceedings, and you can explain the term suit and proceedings. And it should be pending before a court of competent jurisdiction. Here, competency refers to both territorial as well as subject matter jurisdiction. Then the right to immovable property must be directly and substantially an issue. मतलब title का dispute होना चाहिए. Then the suit proceedings must not be collusive. मतलब it shouldn't be a friendly suit. Must not. Here we have already listened. Should not be fictitious. Contents should not be unreal. The property in the dispute must be transferred or otherwise dealt with. Then the 6.8 transfer must affect the rights of the other party to the litigation. So the transfer should affect the rights of the other party. This is the entire doctrine of Lis Pendens. We'll be also dealing with other provisions of all the laws and be making videos regularly with sharing with our short notes as and when, and we will be will try to make easy journey your preparation journey through our Lex Master Academy. Like, subscribe. Thank you.